Your Honors, the Commonwealth of Albania respectfully submits this intervention to address the grave violations of international law perpetrated by the Republic of Alicante. The actions of the Republic of Alicante have not only infringed upon the sovereignty of Albania, but have also undermined the fundamental principle of international law and human rights. Firstly, Alicante's cyber attack against Albania's critical infrastructure constitutes a clear breach of the fundamental principle of the UN Charter, particularly Article 2.4, which prohibits the use or the threat of force against the territorial integrity or the political independence of any state. The cyber attacks committed by the Republic of Alicante targeting critical infrastructure have not only caused significant economic damage, but also pose a serious threat to international peace and security. Such actions have undermined the stability of international order and have set a dangerous precedent for the use of cyber weapons. Moreover, these attacks may have far-reaching consequences, including the disruption to essential services, the loss of life, and the damage to critical infrastructure. Secondly, Alicantes have violated the core principle of international rights law. The allegations of forced labor and exploitation of migrant workers within Alicante's borders constitutes a grave breach of the International Covenant of Civil and Political Rights, or the ICCPR, specifically Article 8, which prohibits slavery, servitude, and forced or compulsory labor. Additionally, these actions violate the principles that are enshrined in various International Labour Organization conventions, or the ILOs, including the Forced Labor Convention of 1930 and the Abolition of Forced Labor Convention in 1957. A state is responsible for the protection and for ensuring the protection of human rights within its territory, regardless of the perpetrators. The forced labor and exploitation of migrant workers not only violate international law, but inflict immense suffering and hardship on individuals and entire communities. Thirdly, Alicante's actions against Albert Shaw. A prominent political figure has raised serious concerns about the protection of political rights and the freedom of expression within Alicante's borders. The disqualification of Shaw from the presidential election based on his political view and alleged foreign influence undermines the democratic principle and the rule of law. This is incompatible with the provision of the ICCPR, which guarantees that the right to participate in public affairs. By suppressing dissent and limiting the political pluralism in the country, Alicante has violated the fundamental democratic norms and undermined the legitimacy of its own political system. Fourthly, Alicante's refusal to cooperate with the UN Security Council resolution demonstrates a blatant disregard for international law and the collective security system. The UN Security Council, as the primary organ responsible for maintaining international peace and security, has the authority to take action to address the threats to peace. Alicante's non-cooperation undermines the effectiveness of the UN and sets a dangerous precedent for other states to disregard the collective organ of security and peace in international stage. Your Honors, Alicante's actions have a far-reaching consequence, not only for Albania, but for the entire international community. The impunity for such behavior could embolden other states to resort to cyber attacks and human rights abuses to gain their own gains. We urge this court to first, condemn the use of Alicante's use of force against Albania. Secondly, to hold Alicante accountable for the human rights violations committed within its territory, particularly forced labor and exploitation of migrant workers. Thirdly, to affirm the importance of international cooperation in addressing cybercrime and the human rights abuses. Fourthly, to order Alicante to make reparations to Albania for the damage caused by the cyber attacks. Fifthly, to declare that Alicante's actions against Albert Shaw were a violation of his political rights and expression. Sixthly, and finally, to urge Alicante to cooperate fully with the UN Security Council resolution and to take immediate steps to address the human rights abuses that are happening within its own borders. By upholding this principle, Your Honor, these principles of international law and human rights, this court can send a powerful message to all the states, a message that such behavior will not be tolerated. We should trust that this court will deliver a just and equitable judgment that will contribute to the strengthening of international legal order and the peace and freedom of our world. Thank you.
As a representative of the Republic of Alicanto, the respondent in this case, here are the arguments answering these two legal issues. The first one is the Republic of Alicanto as a state responsible for the August 2021 cyber attack on the Commonwealth of Moldavia, and the second one is the Republic of Alicanto responsible for not cooperating with the United Nations Security Council? Well, so for answering the first legal issue, we have to say that the Republic of Alicanto has to say that we reject responsibility for the August 2021 cyber attack on Moldavia, while holding Moldavia accountable for cyber activities of the hacker group DedSec, which was originated from Moldavia and targeted our critical infrastructure, making our actions, or can be considered our actions, as lawful countermeasures. Also, we would like to add that Alicanto cyber activities were limited, targeted and defensive in nature, directed only at TLD and DNS servers linked to DedSec, which had carried out disruptive and very harmful attacks against Alicanto's national infrastructure. These actions were aimed at neutralizing an imminent threat to our sovereignty and public security, and were lawful and also proportionate responses to ongoing harm from a non-state actor, which is DedSec. These measures were defensive, targeted, and did not amount to a breach of international obligations. Under the principle also of due diligence, a state is obligated in a certain fact to ensure its territory is not used for activities that are harmful to other states. Also, while the denial of service attacks by DedSec inflicts severe harm to Alicanto, disrupting public access to government services and causing significant economic losses. Such hostile actions initiated without any provocation and cannot be ignored under international law. Additionally, well, it must be said that Moldavia has not provided concrete evidence to attribute the August 2021 cyber attacks on its government system to our state, attribution under Articles 4 to 11 of the RCWA requires demonstrating that state organs or entities acting under state control carried out the acts in question, and no such evidence exists against our state. Also, under Article 1 of RCWA, a state is responsible for its failure to prevent harmful acts by non-state actors originated from its territory. Moldavia failed to exercise due diligence by allowing DedSec, a group operating within its jurisdiction, to launch cyber attacks against Alicanto's critical infrastructure. As for the necessity and proportionality of Alicanto's countermeasures, our state actions comply with Article 22 of RCWA, which permits lawful countermeasures to address an internationally wrongful act. Alicanto's limited and targeted cyber operations were proportionate responses to mitigate the ongoing harm caused by DedSec, by this group. These measures were aimed at restoring compliance with Moldavia, with its international obligations, and also to prevent transnational cybercrime. With regard to the second legal issue about the allegation of non-cooperation with the United Nations Security Council, we would like to assert that our refusal to cooperate with the United Nations Security Council resolution of 217 is justified due to the resolution's infringements of Alicanto's sovereignty and its national security or national security interests. We would like to argue to the UN Security Council that this resolution, 217 resolution, exceeded its mandate by adopting this resolution that imposes investigate procedures into our government, our domestic labor, our domestic practices, and also as a response to DedSec cyber activities. This resolution mandates some inspections within our state domestic industries, disregarding Alicanto's right to non-interference in matters that are fundamental internal of our state. The international law and the UN Charter must acknowledge state sovereignty, particularly that there was no clear indication that these matters threaten international peace and security. Our state would like to again clarify that our measures adopted against DedSec were proportionate and aimed solely at securing national infrastructure from repeated attacks originated from Moldavia and protecting our domestic industries. Also, the sovereignty of our state, which is in danger. Alicante will our state will act within its rights to protect Alitec, which is another, and and also other critical infrastructure from the DedSec actions. Also, we would like to clarify that our refusal with the resolution 217 is justified under the Article 25 of RCWA, which provides the necessity as a defense. The investigations show an imminent risk to Alicante, to our sovereignty and national security, particularly given the sensitive nature of the industry that Alicante has to safeguarding also special interests, such as I mentioned above, sovereignty and also national interests. So now, finally, the Republic of Alicante maintains that Moldavia has failed to exercise the due diligence in committing non-state actors within its territory and has also manipulated international mechanisms to infringe upon Alicante's sovereignty. Alicante, our country, therefore respectfully requests the ICJ to, first, dismiss Moldavia's claims regarding Alicante's alleged responsibility to cyber attacks. Second, Moldavia has violated international obligations under Articles 1, 2, and 8 of RCWA by failing to prevent these DedSec cyber attacks originated from its territory. Third, confirm that Alicante's response to DedSec cyber activities was a lawful exercise of self-defense. And fourth, uphold that Alicante's sovereignty, right to refuse to the UN intervention in its domestic affairs, as mandated under Resolution 217, complying with the fact that this refusal is not a breach of its obligations under international law, but is also justified under Articles 12, 20, 25 of RCWA. Finally, our state seeks a judgment that affirms these points to uphold the principles of sovereignty and non-interference in the face of unfounded international interventions, such as the one we already passed.